Picture a Roman bride on her wedding day, dressed in saffron and veiled in flame orange, about to make a choice that would determine whether she remained a legal person in her own right, or became, in the eyes of Roman law, her husband's daughter, not his wife, his daughter, subject to his authority exactly as his children were, inheriting from him as a child would, owning nothing of her own. So sit back, grab a cup of tea, and get ready to explore how Roman marriage came in two fundamentally different legal forms that determined a woman's entire legal existence, discover why a bride might legally become her husband's daughter through a strange ritual involving spelt cake or a mock slave auction, understand how one type of marriage stripped women of property rights, while the other let them keep everything they owned, and learn what manus and potestas, the trinoctium loophole, and the gradual triumph of women's property rights reveals about why Roman marriage law was far more complex, and in some ways more progressive, than most people realize. Marriage seems simple enough. Two people commit to sharing their lives. But in ancient Rome, marriage was anything but simple. It existed in two fundamentally different legal forms that had nothing to do with love, ceremony, or social recognition, and everything to do with property, inheritance, and legal power. A Roman woman could be married in exactly the same social sense, living with her husband, raising children, managing a household, recognized by everyone as a wife, and yet have completely different legal rights depending on which form of marriage she was in. This distinction between what Romans called cum manu and sine manu marriage shaped women's lives for centuries and influenced legal thinking about marriage that persists to this day. To understand this distinction, we need to start with a concept that seems strange to modern sensibilities: manus. The word literally means hand in Latin, but in legal terms it referred to the power or authority a husband could hold over his wife. Manus was similar to patria potestas, the power a father held over his children, and in fact, a wife under manus was legally treated almost exactly like a daughter. She left her birth family in a legal sense and became part of her husband's familia. She was subject to his authority. She inherited from him as a daughter would, and crucially, she could not own property independently. Everything she had became his. This sounds oppressive to modern ears, and in many ways it was, but we need to understand it within the context of Roman family law, which operated on principles very different from our own. The Roman familia wasn't just a family in our sense. It was a legal and economic unit headed by the paterfamilias, the eldest male, who held nearly absolute power over everyone in it: wife, children, grandchildren, slaves, and property. Everyone in the familia was legally subordinate to the paterfamilias. A son, even a grown man with children of his own, remained under his father's potestas until the father died. A daughter remained under her father's power until she either died or passed into the hands of a husband. This is where the two forms of marriage diverge. In cum manu marriage, literally with hand, the bride passed from her father's potestas into her husband's manus. She left her birth family legally and joined her husband's familia. Her husband, or his paterfamilias, if the husband's father was still alive, now had authority over her. She became, in the legal fiction that Romans used, in the position of a daughter to her husband, filiae loco, as the legal text put it. This wasn't just a metaphor. It had real legal consequences for inheritance, property, and her entire legal existence. In sine manu marriage, without hand, nothing changed about the wife's legal status. She remained under her father's potestas if he was alive. If her father had died, she might be sui iuris, legally independent, answering to no paterfamilias at all. Either way, she did not come under her husband's authority. She remained part of her birth family legally, even while living with her husband and raising children who belonged to his familia. Her property remained hers, or her father's. She inherited from her birth family, not her husband's family. In legal terms, she and her husband were almost like business partners who happened to share a bed. Both forms were valid Roman marriages. Both produced legitimate children. Both were socially recognized. The difference was entirely about legal power and its consequences for property and inheritance. A woman married cum manu and a woman married sine manu might live identical daily lives, same household duties, same relationship with the husband, same social status, but their legal situations were completely different. How did a marriage become cum manu? There were 3 ways, each with its own history and significance. The oldest and most prestigious was confariatio, an ancient religious ceremony that dated back to Rome's earliest days. Confariatio was reserved for patricians, the old aristocratic families, and was required for certain priesthoods. The ceremony involved elaborate religious rituals, including the sharing of a special bread called farium, made from an ancient grain called far, spelt. The bride and groom ate this bread together in the presence of priests and 10 witnesses, symbolizing their union and the transfer of the bride into the groom's manus. Confariatio was the most solemn and binding form of marriage, and also the most difficult to dissolve. Divorce from a confariatio marriage required an equally elaborate counter-ceremony, called defariatio, with priests and rituals to undo what the original ceremony had done. This made confariatio marriages very stable, but also very inflexible. By the late Republic, confariatio was rare, used mainly by families who needed it for priestly offices that required parents married by this rite. The second method was coemptio, which translates roughly as purchase, or buying together. Don't be misled by the name. This wasn't actually buying a bride like property. Coemptio was a legal fiction, a symbolic ceremony that borrowed forms from commercial transactions. The bride was symbolically sold to the groom using a set of scales and a small coin with witnesses present. The ceremony probably evolved from actual bride purchase in Rome's distant past, but by historical times it was purely symbolic, a legal mechanism for establishing manus rather than an actual sale. Coemptio was available to all Roman citizens, not just patricians, and was simpler than confariatio. It didn't require priests or elaborate religious ritual, just the symbolic sale ceremony and witnesses. It could also be dissolved more easily than confariatio, though still requiring a formal process. Coemptio gave ordinary Romans access to cum manu marriage without the aristocratic trappings of confariatio. The third method was the strangest, usus, meaning simply use or usage. Under usus, if a woman lived continuously with a man as his wife for 1 full year, manus was automatically established. No ceremony was required, no witnesses were needed. Just 12 months of cohabitation, and the legal transfer happened by operation of law. This seems remarkably informal compared to the elaborate rituals of confariatio, but it reflected a practical Roman approach. If people were living as married, the law would eventually recognize the full legal consequences of marriage. Usus created an interesting problem for women who wanted to be married but didn't want to be under manus. The solution was elegant and became famous in Roman legal history, the trinoctium, or 3 nights. The law provided that if a woman spent 3 consecutive nights away from her husband's home during the year, the clock reset. The year of continuous cohabitation was interrupted, and usus could not establish manus. A woman who wanted to maintain sine manu status simply had to leave home for 3 nights each year, staying with her father, with relatives, with friends, and she would remain legally independent. This trinoctium rule tells us something important about Roman attitudes toward manus. If manus were universally desired, there would be no need for an escape clause. The existence of trinoctium suggests that even in early Rome, some women, or their families, wanted to avoid manus and its consequences. The law accommodated this desire while maintaining the traditional option for those who wanted it. Why would a woman, or her family, want to avoid manus? The answer lies primarily in property and inheritance. Under manus, everything a woman owned became her husband's property. Her dowry, any inheritances she might receive, any property she brought into the marriage, all of it passed to her husband's control. She could not own anything independently. She could not make contracts or conduct business in her own name. She was, economically speaking, absorbed into her husband's household. Under sine manu marriage, a woman retained her own property. If she was sui iuris, legally independent because her father had died, she could own property, make contracts, conduct business, and manage her own affairs. Even if she was still under her father's potestas, her property remained connected to her birth family rather than passing to her husband. This had enormous implications for wealthy families concerned about keeping property in their bloodline. Consider the inheritance implications. A woman married cum manu inherited from her husband's family as a daughter would. She had no inheritance rights from her birth family because she had legally left that family. Her children inherited from their father's family as expected. Everything stayed within the husband's familia. A woman married sine manu inherited from her birth family, not her husband's. Her father's property would pass to her, along with her siblings, when he died. This property remained hers, separate from her husband's wealth. When she died, her property would pass according to her birth family's arrangements, not her husband's. For wealthy families, this meant that a daughter's inheritance didn't disappear into another family's holdings. It stayed connected to her birth family, potentially returning to that family through her children or other heirs. This created interesting strategic calculations for Roman families. A father might prefer sine manu marriage for his daughter to keep her inheritance within his control during his lifetime, and within his bloodline after his death. A husband's family might prefer cum manu to absorb the wife's property into their holdings. The bride herself might prefer sine manu to maintain her own property rights and legal independence. These competing interests played out in negotiations over marriage arrangements. Divorce further complicated these calculations. Divorce from a cum manu marriage required formal procedures to release the manus, defariatio for confariatio marriages, a reverse coemptio ceremony for coemptio marriages. These procedures were cumbersome and required the husband's cooperation. A woman couldn't simply walk away from a cum manu marriage. She needed formal release from manus to regain her legal independence. Sine manu divorce was remarkably simple by comparison. Either spouse could end the marriage essentially by declaration. The technical requirement was the withdrawal of affectio maritalis, the intent to be married, which could be communicated by simply saying so or by actions that made clear the marriage was over. No ceremony was required, no priests were needed, no formal procedures had to be followed. One day you were married, the next day, if either party withdrew consent, you weren't. This ease of sine manu divorce had significant implications. It meant that women in sine manu marriages had an exit option that women in cum manu marriages lacked. If a sine manu wife was unhappy, she could leave. If a cum manu wife was unhappy, she was trapped unless her husband agreed to release her from manus. This asymmetry made sine manu marriage increasingly attractive to women and their families as Roman society evolved. The history of Roman marriage shows a clear trend. Cum manu marriage dominated in early Rome, but sine manu marriage became increasingly common over time, until by the late Republic, sine manu was the norm and cum manu was rare. This shift represents one of the most significant changes in Roman women's legal status, achieved not through dramatic reform, but through the gradual choices of countless families opting for sine manu arrangements. Why did this shift happen? Several factors contributed. Women and their families increasingly valued the property rights and legal independence that sine manu provided. The Trinoctium rule made it easy to avoid usus, and families simply stopped using confariatio and coemptio for most marriages. Changing social attitudes made the subordination implied by manus seem old-fashioned or unnecessary. The practical advantages of sine manu, easier divorce, retained property, continued connection to birth family, outweighed whatever benefits cum manu might have offered. The rise of sine manu marriage had profound effects on Roman women's legal status. A woman married sine manu whose father had died was sui juris, legally independent, subject to no paterfamilias's authority. She could own property in her own name. She could make contracts. She could conduct business. She could make a will disposing of her property as she wished. She had legal capacity that women in many later societies would lack for centuries. This doesn't mean Roman women had full equality. Far from it. They couldn't vote or hold public office. They faced various legal disabilities and social restrictions. But in terms of property rights and legal capacity, a sui juris Roman woman had more independence than women in medieval Europe, colonial America, or Victorian England. The sine manu marriage system, combined with the possibility of becoming sui juris, created a legal framework that allowed wealthy Roman women considerable autonomy. We see this autonomy in historical examples. Wealthy Roman matrons owned property, managed estates, made investments, and conducted business. Some became influential in their own right, not just as wives or mothers, but as independent economic actors. Terentia, Cicero's wife, managed substantial property throughout their long marriage. When they divorced, she retained her assets and continued as an independent woman of means. Cornelia, mother of the Gracchi, was famous for her independence and influence, managing her household and children's education with considerable autonomy. These examples come from the elite, of course. We know far less about how ordinary Roman women experienced marriage law. But the legal framework applied to all citizens, and the shift towards sine manu marriage would have affected women at all social levels. A freed woman married sine manu had the same legal structure protecting her property as a senator's daughter, even if the amounts involved were vastly different. The social aspects of Roman marriage were largely separate from these legal distinctions. Roman marriage was fundamentally based on consent, the affectio maritalis, or marital intent, of both parties. No ceremony was legally required to create a valid marriage. No registration was necessary. No priest had to officiate. If two people with legal capacity to marry each other agreed to be married and live together as husband and wife, they were married. The elaborate wedding ceremonies that Romans loved, the processions, the feasts, the rituals, were social celebrations, not legal requirements. This consent-based understanding of marriage was remarkably modern in some ways. It meant that marriage was fundamentally about the will of the parties, not about external formalities. It also meant that marriage ended when consent ended. The same principle that made marriage easy to enter made it easy to exit, at least for sine manu marriages. This fluidity shocked some later societies that encountered Roman law and couldn't understand how marriage could exist without formal ceremony or end without formal divorce proceedings. The wedding celebrations themselves, while not legally necessary, were socially important and followed traditional patterns. The bride wore a special dress, traditionally saffron-coloured, and a distinctive veil called the flammeum, flame orange in colour. Her hair was arranged in a specific style. The groom came to her father's house to claim her. A procession led the bride to her new home. Ribald songs were sung. The bride was carried over the threshold. A wedding feast celebrated the union. These customs had nothing to do with whether the marriage was cum manu or sine manu. They were the social recognition of marriage regardless of its legal form. The legal form, cum manu or sine manu, was determined separately, often by what didn't happen rather than what did. If no confariatio or coemptio ceremony occurred, and if the bride observed trinoctium to prevent usus, the marriage was sine manu by default. The absence of manus creating acts, not the presence of manus preventing acts, determined the legal form. This meant that sine manu became the default as the formal ceremonies fell out of use. Roman jurists wrote extensively about marriage and manus, and their writings give us detailed understanding of how the system worked. Gaius, a 2nd century CE legal writer whose institutes survived nearly complete, devoted considerable attention to explaining manus, the 3 methods of establishing it, and the legal consequences of cum manu versus sine manu marriage. His clear explanations have been invaluable for modern scholars trying to understand Roman family law. Gaius explains that a woman in manu was in the position of a daughter, filiae loco, and that this had specific legal consequences. She inherited as a daughter would, taking a share equal to the children. She was subject to her husband's authority as children were subject to their fathers. She could be punished by him, though social norms limited what was acceptable. She could not own property independently. In every legal sense, she was treated as if she were his daughter rather than his wife. This legal fiction seems bizarre to us, but it made sense within Roman family law's structure. The familia was a hierarchical unit, with the paterfamilias at the top and everyone else in subordinate positions. There was no separate legal category for wife under husband's authority. The existing category of daughter under father's authority was simply extended to cover wives under manus. The Romans were practical people who adapted existing legal structures rather than creating new ones when the old ones could serve. The decline of cum manu marriage didn't mean the decline of marriage itself. Romans continued to marry enthusiastically throughout the Republic and Empire. What changed was the legal framework within which marriage operated. By the late Republic, virtually all marriages were sine manu, meaning that husbands and wives were legally separate persons with separate property, connected by marriage but not merged into a single legal unit. This had interesting implications for family dynamics. A sine manu wife was not legally part of her husband's familia. She remained part of her birth family, or was sui juris. Her children, however, were part of their father's familia, under his potestas. This created a situation where a mother and her children were in different familia, subject to different patres familias, or the mother subject to none at all if she was sui juris. The emotional bonds of family didn't align with the legal structure of familia. Some historians have seen this as a weakness in Roman family law, a source of tension between legal structure and social reality. Others have seen it as a strength, allowing flexibility in family arrangements and protecting women's interest by keeping them legally separate from husbands who might mismanage or waste their property. The truth probably lies somewhere in between. It was a system with both advantages and disadvantages, evolved over centuries to balance competing interests. The influence of Roman marriage law extended far beyond Rome itself. As Roman law spread through the empire and was later rediscovered in medieval Europe, its concepts shaped legal thinking about marriage for centuries. The idea that marriage was based on consent, not ceremony, influenced both canon law and civil law traditions. The concept of separate property in marriage, embodied in sine manu arrangements, eventually influenced modern legal systems that allow spouses to maintain separate assets. The distinction between cum manu and sine manu also influenced thinking about women's legal status more broadly. The existence of sui juris women in Rome, legally independent, property-owning, contract-making, provided a model, or at least a precedent, for arguments about women's legal capacity in later periods. When reformers argued that married women should be able to own property, they could point to Roman law as evidence that such arrangements were possible and had worked for centuries. Of course, the influence wasn't always positive. Roman law also contained elements that restricted women's rights, and these too were transmitted to later legal systems. The overall picture is complex. Roman marriage law was neither simply progressive nor simply oppressive, but a sophisticated system that balanced multiple interests in ways that changed over time. Modern scholars continue to debate various aspects of Roman marriage law. Some questions remain unresolved. Exactly when did sine manu marriage become dominant? How did ordinary Romans, as opposed to the elite we know most about, experience these legal distinctions? How much did legal theory match actual practice? The sources are limited, and much of what we know comes from legal texts that describe the law as it should be, rather than as it was actually lived. What we can say with confidence is that Roman marriage law was far more complex and nuanced than simple stereotypes suggest. The image of Roman women as uniformly oppressed, subject to absolute male authority, doesn't match the legal reality of sine manu marriage and sui juris status. The image of Roman marriage as a simple patriarchal institution doesn't capture the strategic calculations about property and inheritance that shaped marriage choices. The reality was messier, more interesting, and more relevant to modern concerns than the stereotypes allow. The trinoctium rule captures something essential about Roman legal thinking. Rather than abolishing manus outright, the Romans created an escape valve that let individuals choose. Those who wanted cum manu marriage could have it. Those who wanted sine manu marriage could achieve it, simply by observing 3 nights away each year. The law accommodated different preferences rather than imposing a single model. This flexibility, this willingness to let legal forms evolve through individual choices rather than top-down reform, characterized much of Roman legal development. As we reflect on Roman marriage law, the distinction between cum manu and sine manu, the 3 methods of establishing manus, the trinoctium loophole, the rise of women's property rights through the gradual abandonment of manus, we see a legal system grappling with questions that remain relevant today. How should marriage affect property rights? What legal relationship should exist between spouses? How much autonomy should individuals have within marriage? The Romans didn't answer these questions the way we would, but they asked them seriously and developed sophisticated legal structures to address them. The next time you hear about marriage and property rights, about prenuptial agreements that keep assets separate, about debates over whether marriage should merge two people into one legal unit or preserve their individual identities, remember that Romans were wrestling with these same questions 2,000 years ago. They developed a system that started with near total absorption of wife into husband's legal identity and evolved towards something much closer to legal equality, not through dramatic reform, but through countless individual choices that gradually shifted the norm. It's a reminder that legal change often happens not through revolution but through evolution, as people make choices within existing frameworks that slowly transform those frameworks into something new. The Roman bride, in her saffron dress and flame-orange veil, standing at the threshold of her new home, was entering not just a household, but a legal relationship, whose form would shape her entire life. Whether she would be her husband's legal daughter, or remain her own person. Whether her property would become his or stay hers. Whether she could leave easily, or would be bound until he released her. All of this depended on legal choices made around her marriage. Those choices, multiplied across centuries and millions of marriages, transformed Roman society and left a legacy that still influences how we think about marriage, property, and the legal status of women today.